let's go ahead and get started. My name is Kate. I am the editor-in-chief of the Utah Law Review, and I would like to welcome you all to the 2021 Lee E. Teitelbaum Law Review Symposium here at the S.J. Quinney College of Law. Our symposium is titled Include Their Stories, Rethinking, Reimagining, and Reshaping Legal Education. The Utah Law Review chose this topic in response to the events of 2020. In 2020, not only did we see the beginning of a global health pandemic, but we also saw a lot of widespread social movements, such as the Black Lives Matter movement, that exposed long existing and deep running inequities that are prevalent throughout our institutions and our society as a whole. This Law Review Symposium recognizes that legal education is one such institution that needs to better equip its educators and its students to recognize and respond to these inequities. One thing that I see nearly every day as a law student is as I read the cases that are assigned to me each day for class, even in the circumstances where the case will, say the ethnicity or gender of the plaintiff or defendant, rarely do the cases ever invite any form of critical thinking as to how that party's ethnicity, identity, or gender impacted their interaction with the legal system. So this symposium seeks to bring together law students, academics, and practitioners to take an innovative look at practical steps that we can take to restructuring the legal education curriculum. Our symposium will be 2 days, today and tomorrow, and each day we will have 3 sessions. Before I get started with our first session for today, I would like to thank all of our panelists who are joining us here today and tomorrow. They're coming from all over, I guess I should say, zooming in from all over the country. And I truly appreciate their willingness to come and speak with us and take time away from their busy schedules. I would also like to thank the IT team and the events team here at the S.J. Quinney College of Law. Events are particularly challenging in the times of COVID, and the events team has put in a lot of time and effort into making sure that the symposium goes smoothly, and I really appreciate it. I would also like to thank our faculty committee for the symposium. The committee consisted of Dean Cronk-Warner and Professors Leslie Culver, Tanil Brown, Erica George, Beth Jennings, and Christine Kim. The committee brought a lot of invaluable insight, experience, and knowledge, and devoted a lot of time into making the vision that was the symposium become a reality. I'd also like to thank Amanda Fuller. She is our executive symposium editor here at the Utah Law Review. And she's dedicated countless hours to the symposium as well, and has truly done an amazing job leading and coordinating and organizing the symposium. I'd also like to thank and acknowledge Professor Ronelle Anderson-Jones. She is our Law Review faculty advisor, and she advised us on the symposium, and her advice is truly invaluable to us. So today we will have 3 sessions. The first 2 will be panels, and after those 2 panels, we will hear from our keynote speaker. Our first panel today is focused on grappling with our legal history of exclusion. The panel will be moderated by Meg Glassman, who is a member of the Utah Law Review and a 2L student here at the S.J. Quinney College of Law. So with that, I will turn the time over to Meg to introduce our panelists and get us started on our first session. Thank you.
Thank you so much, Kate. That was a wonderful introduction. My name is Megan Glassman, and I am a 2L here at the S.J. Quinney College of Law. I am a junior editor with the Utah Law Review. I will serve as the moderator for this panel, which is entitled Grappling with Our Legal History of Exclusion. Our panelists today are Angela Winfield, Joann Thach, and Dr. Tom Romero. I will be giving some bios for these wonderful panelists, and then they will be proceeding to talk about this important issue before we go on to a Q&A panel later, or Q&A discussion later. Dr. Tom Romero is a nationally known interdisciplinary legal historian of the racial landscape of the American West. Dr. Romero's work brings together issues such as immigration, school desegregation, property, land use, urban development, and water law. He has documented in numerous articles, essays, and book chapters the battle for racial equity, and justice in the region. Currently, Dr. Romero is revising a book manuscript on the legal history of race relations in post-World War II Denver, Colorado. He is also working on several projects related to the multiracial history of water justice. Those projects include a book chapter that examines the intersection between water development and immigration law in the late 19th and early 20th centuries, and a community-based participatory research project on water access and water quality issues impacting a Latinx neighborhood in Denver, Colorado. Dr. Romero received his PhD and JD from the University of Michigan and was part of the founding generation of critical race theory students and the Chicano Latino Law Review, among others. Angela Winfield is Chief Diversity Officer for the Law School Admission Council. In this role, she provides leadership, vision, energy, and a unified philosophy to LSAC's diversity, equity, and inclusion efforts on behalf of member law schools and the students who seek a career in law. Prior to her current position, she was an Associate Vice President for Inclusion and Workforce Diversity at Cornell University, where she led the university's affirmative action and federal contractor compliance programs, managed the university's 5 identity and affinity-based colleague network groups, provided training for the 7,000 plus member staff, oversaw religious accommodations, and served on the university's ADA coordinator team. She is a certified leadership coach and motivational speaker and has presented to companies including 3M, Societe Generale, and LexisNexis. She also is an advisory board member for the Burton Blatt Institute at Syracuse University, and Angela serves on the board of trustees for Cayuga Community College. She also sits on the board of directors for the Rev Theater Company, Reader's Digest Partners for Sight Foundation, and Success Beyond Sight. She earned her JD from Cornell Law School and is admitted to the New York Bar. She earned her BA from Barnard College of Columbia University. And our last panelist is Joann Thach. She is Snell and Wilmer's Senior Director of Diversity, Equity, and Inclusion. She oversees the firm's commitment to expanding and supporting diversity, fostering an inclusive culture, and supporting initiatives that positively impact the community, the greater community. This includes working with the firm's Diversity, Equity, and Inclusion and Women's Initiative Network committees and affinity groups, and its efforts to retain and promote top talent. She has a long history and passion for advocating for justice, equity, and inclusion. Prior to joining Snell and Wilmer, she spent a number of years leading recruiting, training, and corporate social responsibility efforts with a lens for diversity and inclusion at an AM Law 100 firm. She spent her early years of her career expanding access to colleges and legal services within low-income communities. She received her undergraduate degree at UCLA in sociology and philosophy and completed an intensive critical race theory and intersectionality program sponsored by the African American Policy Forum in partnership with Columbia Law School and UCLA School of Law. Without further ado, I will now turn the time over to Tom. Thank you.
Good morning, everybody. My name's Tom Romero. I am a faculty member at the University of Denver Sturm College of Law and an affiliated faculty member in the Department of History. It's such an honor and a pleasure to be here today, to be with my fellow co-panelists, Angela and Joann. Very quickly, want to just thank the Utah Law Review and all the student and symposium organizers that have done such a thoughtful and tremendous job for organizing this conversation and for having the courage to take this on, these issues on, as we know, in a time of great backlash, to being able to talk forthrightly about these issues. I also wanted to acknowledge the fact too, we continue to be in a global pandemic. I know there were plans for us to all be in person, and we have to do this virtually. And certainly want to just acknowledge everyone that has been on the front lines over these last almost 18, 19, 20 months now. The frontline workers, the healthcare workers, all the support staff at everyone's universities and their places of employment that continue to allow us to have the privilege to have these sorts of conversations. So let me get started here. My goal today and setting up this very first Panelist Symposium is really kind of set a framework and a groundwork into some of the ways that these issues of racial inequality and other inequities appear in the law, in our history, in our contemporary reality. Let me start off by framing this a bit in relation to my own story with the symposium theme. I was born and raised in Denver, Colorado. My paternal side of the family goes back 8 generations to Southern Colorado, what we now know as Southern Colorado and Northern New Mexico. I am Latinx or Chicano. And there's a saying on at least my parents' side of the family that, we never crossed the border, but the border crossed us. And my maternal side of the family, my maternal grandparents were fleeing the Mexican Revolution. And they came over to the United States in the late 19 teens. They started out working as migrant farm laborers, a more familiar story and trope that y'all may have heard. And they ultimately ended up settling on the western slope of Colorado in this small town called Olathe, Colorado, where they actually saved up enough money to buy a family farm. And I remember spending my summers on that family farm, learning how to swim in an irrigation ditch, and of course, understanding and getting to know the larger rural West. Final sort of piece, my families came together in connection to what was a larger migratory and community of Spanish-speaking, Latinx, Chicano people that were part of an Assembly of God Pentecostal community that was connected between Colorado, New Mexico, and Utah. And as a matter of fact, my paternal side, my parents, my father, even though he grew up, was born in Southern Colorado, he ended up with his family migrating, following with my grandfather, work on the railroads, where they ended up first in Price, Utah, and ultimately in Salt Lake City. And so my grandfather was a janitor in the Salt Lake City Public Schools, and my father went to West High School, which I know is not far there from the Utah Law campus. So those stories, right? That background, I think, is really important. You're probably wondering who this brown buffalo is. And so let me give you a little context about what that means. And when I talk about the brown buffalo, what that looks like. About 10 years ago, I wrote an article that was specifically trying to bring into conversation those that were doing water law, water policy, into those that were writing about and thinking about racial justice and racial inequity. And anybody who knows water law in the American West in particular knows that the most powerful water lawyers, the most powerful water people are called water buffaloes. And so I did this conceit. I invoked the persona of Chicano movement lawyer Oscar Zeta Acosta to insert into the conversation what a Latinx or a perspective from person of color would look like when imagining and thinking about and understanding water law and policy. So that's the brown buffalo. And I have used that conceit of the brown buffalo kind of repeatedly over the years to really sort of highlight and center the importance of a racial justice lens and how we understand law, how we understand history, how we understand politics. So as I said, my frame today is to really get us to think about what this means in context of the region, right? The region where many of you who are students are studying, many of us that are faculty or staff and or employees that are working in the Rocky Mountain West, have come to think about issues of race, issues of racial inequity. And so I start out here with a sign that many of you might be familiar with. And when I do these types of presentations, I ask people, what does this sign evoke, right? And people will say Purple Mountains Majesty, Red Rocks in Colorado, or you might see here in Utah, right? The sort of golden fields of grain, right? But what's missing from both of these slides, right, as you think about it, is people, right? Is people. So my job today is really to insert how people, and in particular, this landscape of the Rocky Mountain West came to be inscribed, right, by very different understandings of racial equity, and certainly by racial inequity over the course of many decades. And so this is really the story I get to tell you today. This is the perspective of a person who was born and raised in the region, who has family that goes back generations, right? That knows the region well and has moved and has navigated sort of the scope and the issues of difference and racial difference in particular among communities. So a few notes here on terminology, and I just want to make sure we're all here on the same page. All of us are familiar, right, with the term race. And I just really want to highlight something really important here, right? It's not a biological fact. We know it's a social construction. It's based on history. It's based on ideas. It's based on attitudes, right? But what makes race real, right? What makes racial inequity real? Well, it's really law, right? And so when I talk about the color line, that's really law making these racial differences meaningful, right? Because what does law do? It distributes rewards or punishes, right? And so I think having that idea of the color line, I think is centrally important, right, to our thinking about these issues, particularly in the region, but also across the nation. And in the region here in the Rocky Mountain West, what some of my presentation here today is really going to talk about this tension between color consciousness and color blindness, right? This is a region that has long prided itself for not having the issues of racial inequality, of racial injustice that has impacted other parts of the United States. But nevertheless, it is deeply embedded, right, with a long and problematic history. And so really that's one of my jobs today is to get us to be thinking in more color conscious sorts of terms and really to disrupt, right? And in some ways blow up this idea, right, of colorful Colorado, this landscapes that are void of people, of history, and certainly of race. All right. Very quickly too, I just want to point out, what part of my presentation is built upon a long and rigorous body of research and scholarship. This presentation owes some of its thinking to Richard Rothstein, right? And his book, The Color of Law, the sociologist Eduardo Bonilla Silva, who I got to study with when I was a graduate student, who talked about this idea of racism without racists. Tom Guglielmo, one of my great friends and colleagues, who talked about the fact that when Italians came to the United States, as soon as they stepped foot on the shores of the United States, they were white, right? And this is the idea of the color line. And I think most important, and then of course, we're finishing this off, Natalia Molina, who just recent MacArthur Award fellow, who helps us think about the ways that these issues of race and color blindness and color consciousness are really part of a larger narrative, right? And I think we need to understand that narrative as we begin to unpackage what this means as a matter of the law and both our history, our present, and certainly our future reality. All right, so I am going to fly through a lot of history here, and don't feel like you're going to be missing things. What I really want you to do is really invoke some imagery as I walk us through. First of all, this tension of the Rocky Mountain West as having this tension between color blindness and color consciousness. I then want to talk specifically about how the law embedded color lines in a variety of different contexts. I would be remiss if I didn't talk a little bit about what this means in relation to the West's most precious and resource, water. I then want to bring us back to the present. And I then sort of really want us to give us a couple of tools to think about how we move forward. And that should set up the conversation. Some of these images, just want to warn, are graphic in nature. They can be triggering, right? They invoke images that are disturbing, right? Images that are certainly connected to historical as well as contemporary trauma. And so I want to certainly highlight and point out that fact. All right. So let me get here into the first part of this presentation, the American West as incomparable, color conscious, and colorblind space. So I'm going to talk about something I've been doing a lot of around Colorado, right? It's talking about this tension as it's appeared in a state like Colorado. And this was true of many states in the Rocky Mountain West. They were seen as these racial utopias. In Colorado, right outside of Denver, there was this town called Deerfield that was a really kind of a utopia for African Americans who were leaving the South, who were leaving the Midwest. And it was a city, or it was a small town that grew to great prominence in the late 19th into the early 20th century because of the opportunities that were afforded to be farmers, to build businesses, right, to create capital. And so it was certainly promoted, but not just in Colorado, but around the United States, right, as this racial utopia, right, for the Black community. Of course, we know, right, in Colorado, the rise of the Ku Klux Klan. Colorado became the epicenter of Ku Klux Klan activity in the 1920s. The governor of Colorado was a Klan member. The mayor of the city and county of Denver was a Klan member. One of its US senators was a Klan member. The majority of state legislatures were members of the Klan. And the Klan had a reign of terror in the city, right, that certainly came to prominence as a matter of politics in the 1920s, but certainly resonated, was part of a previous history and resonated well into the present day. So this tension, as we sort of move forward, we also know that in the 1980s, Mexican-American mayor was elected, the first person of color elected as mayor of Denver in the 1980s. He brought together a multiracial coalition that sort of imagined a city that was better and beyond its sort of history and its past, right? And so this seemed to highlight some of the hope of the future. But of course, and this was graffiti that appeared on a home not far from where I live in the Denver area, right? These ideas of white supremacy, these ideas of racial inequality, right, were deeply embedded and continue to appear on the landscape. So what explains this, these sorts of tensions? Well, first of all, I think it's important to know, right, that the Rocky Mountain West, the larger American West, was forged in the context of multiple state-sanctioned wars, right, against oftentimes people of color. First, the United States' war against Mexico, right, with the idea that Mexicans, because they were mixed race, they had indigenous, they had African and sort of mixed race blood, were unfit, right, for self-government. Certainly this was true, right, if we think about the different ways that Native Americans, right, were moved off of their lands, right, were in war and in conflict, and oftentimes were massacred, right? This is the Sand Creek Massacre, where Arapaho and Cheyenne elders, women and children who were flying under a flag of peace were nevertheless massacred by the US cavalry on the shores of the Sand Creek in November of 1864. But this is also a region too, right, that also seemed to promise the future of equity and equality and justice and freedom in the United States. My colleague, Susan Schulten in the history department, right, has talked a lot about this region really being at the center of the struggle, of the Civil War struggle, about how slavery and larger notions of equality would play themselves out. Here's sort of another way to think about that, right? In terms of the law, right, we see color consciousness being embedded in the territory of Colorado and other states, right, as soon as they were formed. But this tension between color consciousness, color blindness, right, the hope and the promise and opportunity of what the region could be also played itself out in different ways. Colorado Constitution had a provision in 1876 that required all of its public acts to be in multiple languages, not just English, but also Spanish and German. There was a slavery prohibition, right? It provided for the property rights of immigrants. And so again, right, sort of really think through that tension, this tension between color blindness and color consciousness. All right, so let me go get here then into the second part of my talk, where I talk then about how this sort of plays itself more precisely in terms of the law and the landscape in which people are living, working, going to school, right? A place like Colorado, like many states in the American West, had racial restrictive covenants, right? These were enforced by law, right? They prevented, right, people of color from living in certain neighborhoods. In a place like Denver, where I'm at, right? If you look here, this map shows all of the stars where the racial restrictive covenants are, right? These racial restrictive covenants were designed, as you see here, right, to really contain Denver's multiracial communities of African Americans, Mexican Americans, Japanese Americans, as well as Native American and Indigenous peoples. This was reinforced, right, through the acts of private actors, as well as the federal government that's relying on these sorts of redlining maps, right? So there's a perfect tracking here, right? The red areas, all right, are those areas that have your majority communities and neighborhoods of color. And since we're at the Utah Law Review, right, and this was also happening in a place like Salt Lake City, right? So here's the redlining map for Salt Lake City. And if you see here in a perfect tracking, some of the best neighborhoods, which were exclusively white, were those that were near the University of Utah. We also see this as well through the establishment of anti-miscegenation laws. Colorado, like many states throughout the Rocky Mountain and American West, prevented the marriage of Blacks and whites, right? And we see this, right, play itself out in a variety of contexts, not just necessarily applied to Blacks and whites, but to whites and multiple non-white groups, right, which make up a very important part of the history of the American West. In 1942, the Colorado Supreme Court upheld, right, the marriage ban. Immigration and martial law. One of the things that happened in Colorado in 1935 and again in 1936 is the use of martial law, right, to close down the border between Colorado and New Mexico. As I tell people here in the state of Colorado, I don't know how many people knew that Colorado was an international border, right? But apparently it was. And what had happened was a massive fear, right, and a massive public campaign against Mexican immigrants, right, that were coming to the state to quote unquote take away jobs, right, from worthy Americans. And so the governor of Colorado, right, used his military powers to declare martial law. And these are some of the images, right, that are appearing in the newspapers, right, in Colorado, right, and the Rocky Mountain West, right. There is a literal war, right, against Mexicans and Mexican Americans. Well, who was this war against? And I sort of prefigured it. It was against families, right? And many of these families, almost all of them, were exclusively American citizens. They were coming into Colorado as part of a larger migratory stream of agricultural laborers, usually coming from New Mexico, Texas, right, and those sorts of places. This, of course, plays itself out too in education law. Denver, Colorado, had its public school system had the first non-Southern school desegregation case to reach the United States Supreme Court. And there were a couple of really important issues in this case. One is, what do you do as a matter of racial identity for Mexican American students? And let me just sort of spell out quickly what that means. If you have a school that's one half Mexican American and one half African American, and if Mexican Americans are considered white, what do you have? An integrated school. But if Mexican Americans are considered non-white, then you have a segregated school. And so in the late 1960s, early 1970s, the United States Supreme Court is undergoing a really sophisticated analysis about what racial discrimination looks like and racial inequity looks like. And the court ultimately concludes, though of different origins, the consequence of segregation for Mexican-American students is the same. So that was one of the big issues the court had to decide. But it also had to decide too, this issue of there was no official policy or practice of of segregation in the Denver public schools. Nevertheless, and particularly in the 1950s and 1960s, as you see here, communities of color are moving out of their once segregated neighborhoods into more integrated neighborhoods. Schools continue to be segregated. And what you see up here is the parents knew this, right? The students knew this, but they couldn't quite put their finger on what was going on, right? And ultimately, over the course of the trial, you really start getting some real fascinating things that began to happen, right? And so, sort of invoking, right? These are the maps, right, that start to appear. And what the maps ultimately showed is that beginning in the 1950s, the Denver Public School Board every year would manipulate its attendance boundaries to maximize segregation of its schools, right? And that was maximizing using all of these other maps, right, to really continue to perpetuate segregation. There, of course, was great backlash to it. There, of course, was questions about what integration should look like, right? And there was violence that was happening in the street. Denver school buses were bombed, right? So that's part of the history, right, of the West. Let me quickly here turn to how this plays itself out in colorblind ways, right? One of the things to sort of talk about is the fact that there's always this mismatch between where the water is and where the people are, right? So cities in particular, right, are charged with moving water and getting water, right, to its community and to its citizens. And what we see in a place like Denver, and I think in many places across the United States, if you think of places like Flint, Michigan, right, is that the water supply was inequitably distributed, right? And oftentimes those that had the oldest, right, and least capable or least clean or complete lack of water supply were communities of color, right? What did this look like? I think in a couple different instances, and I sort of want to focus here on a couple things. Well, some people, right, in some communities had water supplies that were completely unusable, right? You see here in this slide, water had 99.9% refined gasoline, right? And of course, what was the retort to it, right? If you don't like the water, you have the privilege of moving. But of course, this is privilege of moving to where, right? Tied to issues of segregation, tied to issues of policing, tied to issues of certainly racial steering. All right. So let me finish up here with the last 2 points of my talk and my context. In 2013, we know we had this really important voting rights case that has really shaped certainly the landscape of voting rights in the last decade. And Justice Roberts, in really striking down the Voting Rights Act, right, or provisions of certain provisions of the Voting Rights Act, have talked about how things have changed dramatically in the United States, right? There is no longer the need for these provisions to deal directly and forthrightly, right, with racial inequality and racial injustice. And so one of the things I sort of want to talk about is how much have things changed, right? In many neighborhoods like Denver, certainly Salt Lake City, right, formerly segregated neighborhoods, right, have become gentrified, right? And it certainly has sparked a big backlash, right, about what that has meant, right? We have continued to have massive patterns of policing, right, that have led to violence and death. We have the example of Elijah McClain here in Colorado. We, of course, have, as a result of this history, right, huge gaps in terms of economic inequality, huge gaps in terms of educational inequality, right? We know that communities of color are over-policed. We know that a modern police state, right, has had huge overinvestments in the face of declining investments in education and in health. And of course, this is all sort of prefigured by the fact that we actually are more segregated in the Rocky Mountain West, actually throughout the United States, than at any time in our history, right? And this is certainly tied to this tension, again, between color blindness and color consciousness that is happening. All right, so let me finish off here, and I suggest a tool here, and I don't put it up here on the slide, but I do this in some of my other writings and work, where I think that particularly when we're thinking about the law and we're thinking about policy, we should do things like we do in the environmental field, and that is to start bringing racial impact statements, like environmental impact statements, to understand the impact of certainly the policies and the laws that are being proposed. And we have seen great success with this in the criminal justice reform field, right? And what does it help us do, right? It helps us understand, right, the changing and the rapidly changing nature of race and racial inequality, right, in certainly the United States and certainly the region, right? One in which we are continuing to become, right, as a region, we're going to continue to have communities that, of color, right, in much larger proportions, and continuing to be challenged, right, in relation to this history. This one of these final slides here is to talk about the importance of why do we need to be color conscious, right? Why should we have things like racial impact statements? Well, there's a net benefit for all, right? These slides here show that the economy of Colorado, if we were to address these racial inequities, our economy would be $30 billion bigger and better, right? And of course, this deals and impacts a variety of different groups. So I leave us here with questioning, right? Sort of this idea of how much things have changed. And I certainly encourage us to think about the larger history, right? And how history really frames and should help us think about this conversation. And ultimately, I hope for all of us, right, that as you think of these signs, right, and you certainly think about these issues for yourselves, right, that this is the story, this is the landscape, right? It's a landscape filled not just with a colorful natural landscape, but it's a colorful people, right? It's a people that are shaped certainly by a racial history, other inequities, right, of gender, of sexual identity, of economics. And of course, these intersect and layer on top of one another. And so understanding and seeing this, right, as the landscapes in which we work, in which we worship, in which we go to school, is centrally important to how we certainly understand law and our legal system. And thank you.
Thank you so much, Tom. So this is Angela Winfield. I'm the Chief Diversity Officer for the Law School Admission Council, and I am absolutely delighted to be here with you today and to participate in this symposium. I think Tom's comments really set up the context for and the history for why we're having this conversation, right? Really grappling with the history of exclusion in the law and how the law has been a part of exclusion. So I want to just talk very briefly about three things. One, I want to put a fine point on the context and the historical context and the legal context of exclusion, that the law is extremely powerful and it plays an incredible role in not only excluding, but including, and as a tremendous part of the progress that we need to make is embedded in the law and the legal system. The second thing I want to touch on is what it means for us today and what it means in the legal education context. And then finally, I want to move and talk about how organizations, many of whom are participating in this symposium, as well as LSAC, have been trying to implement real world and practical solutions to help improve inclusion, diversity, and equity. So going back to the context, what I want to put a fine point on here, because I think Tom covered it extremely well and gave a wonderful history of the law. But what I want to put a fine point on is the law is powerful, right? The law, the legal system had the power to create borders, to create rights, to take away rights, to empower people and to disempower people. And if we go back even further, if we go back to the history of slavery, and I'm not going to go deep into the history of slavery, but I do just want to point out that in the country, in our country, the US, and this is going to be a US-centric approach, in this country, the law had the power to not only create race and determine who was and who was not white, but it had the power to take people and dehumanize them. So for instance, if we think about slavery, when we think about the laws that protected slavery, certain people, Black people, namely, were not people, right? The law made them chattel, right? That's how they showed up in our legal system. And it wasn't until the laws changed, until cases came before courts, until attorneys and the legal system pushed back against existing laws, then existing laws, to create more equity and actually recognize that enslaved persons were actually persons and not chattel, right? That was through the law. And I think it's important to note this because the legal profession and those in it have a very heavy responsibility, right, to move things forward and are very uniquely situated to actually make a change and make difference. That is the context that I come at this with, is that the legal profession and joining the legal profession is a tremendous honor and privilege because through legal education, through legal training, you're learning and understanding how systems are created, how systems can be changed, how to navigate various laws, and how to look critically at what those laws do and the impact of them. And so if in the past, which is the case, that the legal system has perpetuated systems of oppression and has perpetuated things like racism and genderism and other isms based on identity, the law can also empower inclusion, right? And to empower people. And what does that look like? So the reason why I want to talk about this is because not that long ago, it was in the last decade, so in this century, I remember presenting at a law firm. And this was a diversity, equity, and inclusion presentation to a room full of attorneys at a large law firm, highly ranked law firm. And in the room, it was primarily and predominantly white men who were the partners. There were some female partners, but very few. There were also a variety of associates there. And that's where the diversity was. And it wasn't a tremendous amount of diversity, but there was a scattering of diversity. And the part of the presentation was to show a clip from the video called Race, the Power of an Illusion. And this was a PBS docuseries that talked about race, that talked about the history of it, how it was created. And there was a particular segment that talked about law and the various cases of how race was created through laws and reinforced through the laws. And after showing this clip to these attorneys, a room full of attorneys, it was surprising yet not surprising, their reaction. Many of them did not know this history, right? This was not taught to them. They did not know, or maybe they did not remember from law school, these particular cases and how the legal system really shapes what we do. And it was eye-opening for them, and it was also eye-opening for me. And I think that's an important story that kind of illustrates why it's important to really grapple with these issues and to remember how these things play out in the law. So second, what I want to talk about is what this means and why I'm talking about this and how it relates to today and how it relates to legal education. So I'm not going to get deep into the statistics, but I do want to just point out that there is still a large disparity. And if you want the statistics, you can ask and we can talk about those. But there's a large disparity if you look at the overall US population compared to the demographics of those who are attorneys and who are practicing in the profession. And the disparities are race-based by, Black, Latinx, Asian, there are disparities. There's also disparities when it comes to sexual orientation and those who are out in the LGBTQ community versus those who are practicing and out, as well as with respect to disability. Right, there are way more individuals in the US population who identify as having a disability as compared to attorneys who identify as having a disability. And these disparities in part come from this history, right? This history of being excluded from the law, from being excluded from participating in society as full practicing individuals, and also from being seen and a part of the legal system. And I'm going to break it down and show you, at least tell you about an example that is very, very recent. So I'm the CDO, and I recently joined LSAC in this role as CDO. And part of what I'm doing in my time here is a listening tour. And I'm actually in the middle of the listening tour right now. I've got 3 months in, 3 months to go. And I'm out talking to a variety of stakeholders, including students, pre-law students, high school students, college students. And one of the themes that is coming out when I talk to these students is that not all of them realized that the legal profession was something for them. They didn't realize that they could be included. They never thought about it until someone showed them or told them or encouraged them that this can be something that you pursue. It can be a career path for you, right? So there's this lingering sense of exclusion, even if it's not expressed, it is implicit, right? Because of the demographics of the profession and the lack of diversity in the profession, that it doesn't reflect our society. It does not reflect the people that the system is meant to serve and represent. Now, change is happening. I don't want to paint a dismal picture because progress is happening. It is slow, but it is there. And we can see that on the education front that there has been more interest in the law. In our 2021 cycle of admissions for law school, applications overall were up by 13%. That's overall. And if we break that down by race category, by Black and Latinx, for Black applicants, it was up by 12%, and by Latinx applicants, it was up by 13%. We are also looking at high test scores, high LSAT test scores for applicants, and scores in the highest range of 160 to 180 were up overall by 34%. For Black test takers who were applicants, it was up by 49% in that high range, and for Latinx by 44% in that high range. And then another statistic that is really encouraging is that of the ABA accredited law schools, 14% of law schools are now being led by deans who are women of color. So change is happening, right? There are doors that are opening, and there is more diversity coming into these roles. And I think that's really important. And the reason why it's important that we have more diversity is because the perspectives of people from these marginalized identities and minoritized backgrounds helps to move the legal profession forward. It helps to move the laws forward. It helps to apply that lens that Tom talked about, that race impact lens, and if we can even broaden it and say that equity lens to the work that's happening in the law, to the education, to the curriculum in law schools, and also to the practice of law. The third thing that I want to talk about briefly is some of the initiatives some of the initiatives that are now taking place to help diversify the profession. And I'm going to talk specifically about LSAC and some of the programs that we do. And the reason why I'm talking about them is not only because I represent the organization, it's because of the approach that we're now taking. And it is a candidate-centered approach, and it's centering the experience of minoritized and marginalized folks, right? Really looking at what are their stories, right? Keeping in mind that we're talking about how do we include, one of the ways of including is actually listening to and centering and hearing the voices, stories, and experiences of individuals who have been historically excluded. So one of the ways that we're doing that is in our pre-law undergraduate scholars program. We call it our Plus program. And in that program, we partner with law schools to help support undergraduates, usually sophomores and juniors who have an interest in law, to really explore what it means to be a part of the profession, what it means to apply to law school, what it means to be a law student, and how to get the support and resources needed to pursue that path. We've done that for nearly 2 decades in a variety of capacities. And this year, we will be continuing that. And we're also making changes to make sure that we have heard the voices of our students who have participated in those programs and are really responsive to the needs of our candidates, because this is the pipeline to the profession, right? If we're going to widen and try and diversify this pipeline to the profession, we've got to listen to and be responsive to candidates. And then the other thing, just to close before I turn it over to Joann, is that when we diversify the pipeline with an eye towards improving access and equity in the legal profession and to support diverse, talented candidates in their journey from pre-law through practice, and that's what LSAC does, when we do that, it's also important to look at the profession itself, right? To really understand, is the profession ready, willing, and able to welcome this new sense of diversity, to welcome and grapple with these issues and to help make progress. And I think that's something that's really important, right? It's not just about the pipeline, it's about what that pipeline leads to, and it leads to a legal profession. So I'm going to stop there so that we have time to hear from Joann and also time for discussion. But I'm going to turn over to Joann to hear her perspective and to hear her thoughts about the profession and what is happening at that end of the pipeline. So thank you so much for being here, for showing up. Thank you for having this symposium. It's been an absolute pleasure, and I look forward to the conversation to follow.
Thank you, Angela. Hi, everyone. It's such a pleasure to be here with you all and my co-panelists, Tom and Angela. So my name is Joann, and I'm Snell Wilmer's Senior Director of Diversity, Equity, and Inclusion. Thank you all for being here and partaking in this important topic. We're currently in a pivotal point in history where diversity, equity, and inclusion is at the forefront of conversations at an individual, an organizational, and societal level. And under the backdrop of the pandemic, social isolation, and acts of social injustice, it's a perfect storm for us to really face history and come to terms with where we're at today. Now, Tom has given a really great overview on the history and foundation of this important work. And to add to that, from a law firm perspective, diversity, equity, and inclusion is not a new phenomenon, although many think it is. Clients have been holding law firms accountable for diversifying their teams since 1988, back when the general counsel of General Motors sent a letter to his outside counsel stating that GM wanted to see minorities and women handling GM's legal matters. There were spurts of other public demands for diversity on teams in the 1990s and the early 2000s, such as the Statement of Principal Diversity Pledge and a Call to Action Pledge. And despite these concerted efforts to hold law firms accountable and responsible for diversity, the progress within the legal profession has been slow and honestly disappointing. And you may start to wonder, why hasn't the needle moved? And I think this is when we need to look to history to understand how different communities have historically been impacted and treated differently. When we look at cases like Plessy versus Ferguson, legitimizing racial segregation, or Ozawa versus United States, denying someone's citizenship on the basis of race, we start seeing snapshots of the current attitudes and perspectives at a given point in history in light of historical events, inadvertently creating an insider versus outsider dynamic. And the creation of Japanese internment camps during World War II, or the Chinese Exclusion Act of 1882, drives this point home, showcasing the biases that people in positions of power may have towards people in communities that are different. And my point in citing all these events is to underline that people in communities who are considered outsiders, or the non-dominant group, are routinely affected by choices and decisions people make through law and policy. Now, legal departments demanding for diversity and holding law firms accountable is one step towards the right direction. But in execution, when we look at this from a behavioral level, it comes down to how we make decisions and how intentional we are in being inclusive to people who are considered outsiders. This boils down to confronting our implicit biases, looking inward at ourselves, and engaging with curiosity about our attitudes and our beliefs with each other while respecting differences. Are we intentionally being inclusive and creating space for people who are different from us? And when we look at studies and statistics of the legal profession, we routinely see a mass number of women and minorities entering the legal profession, but a dwindling effect of women and minorities not making it to the upper echelons of law firms. Angela briefly touched upon this, but women comprise the majority of enrolled law students. But when we look at the top, at the partner level, women only make up about 22% of law firm partners. And so you see a similar effect with underrepresented communities. This is problematic for a variety of reasons. And I'm going to quote Tom here. Things have dramatically changed. And the Pew Research Center shows that Generation Z is slated to become the most diverse generation yet, and a number of them haven't even entered the workforce. There's a current demographic and attitude shift that is happening today, largely being driven by the younger generation. And I'm of the mindset that businesses and organizations need to be able to adapt to this shift or future-proof their organizations to continue to survive and remain in business. And this is a glaring issue that I routinely manage in my role. And the bottom line is that we need to reimagine and redesign historical processes, systems, and infrastructure to enable those who are considered different to succeed in the environment that they are in. And so I will pause there because I want to make sure that we have ample time for Q&A and engage in various discussions.
Well, thank you so much to all of our wonderful panelists that have presented on this really important topic. We have numerous questions posed by our student audience, and I am really looking forward to hearing your responses to these very insightful and thoughtful questions. One of the first I would like to pose is one that is a theme throughout our questions we've received today, which is issues of tokenism and a lack of representation that many of you have already presented upon. We don't have the same reflection of those in partner roles as those students entering law schools. What are your recommendations for improving this issue, improving representation among those in partner roles and in other various capacities within law firms and outside of law firms? And what are your views on reducing the push toward colorblindness and toward something other than colorblindness in our present society?
So I'm happy to start, and then my panelists can certainly fill in. In terms of representation and how we actually make progress there, it's a difficult, challenging issue. And if I were to say that I have the answer, you should not believe me, right? Because this is a vexing problem that we have not been able to solve in decades. That doesn't mean we don't have to try and that we don't have an obligation to try and make progress. So I can tell you my approach and my thoughts and how I look at this work and how we're trying to move it forward at LSAC. So one of the things that I think is really important when we think about demographics, for me, yes, we do want representation. That's probably the end goal, but we don't get there through just putting people into positions necessarily, right? One of the things that's really important is the environment. What is the culture? What are the structures and the systems there? Because as Joann noted in the statistics, what we see is law school classes are quite diverse. Maybe not as diverse as they need to be or should be. There's more that we need to do there, but they're quite diverse. That does not carry through. And part of the reason I think, is because organizations need to hold up the mirror to themselves and actually look at their processes. Is it conducive to maintaining diversity, right? Even if you open the door, what does that door open to? And that's kind of what I was alluding to towards the end of my comments, is that when you have a pipeline, when you have an experience at law school, are we thinking about minoritized identities? Are we thinking about and presenting information, resources, and just the general experience from that perspective? If not, we need to. The same thing happens in law firms and other legal employment settings, right? Okay, we open the door, we say we have diversity, but when you get there, is there equitable ways of distributing work and allocating work? Are opportunities fairly given to folks from minoritized backgrounds? Are there the same networking opportunities, the same opportunities to connect with clients? Those are the things that we really need to be looking at, because if you open the door to an experience that is still feels like you're being excluded, diverse candidates and diverse folks won't stay. So we need to do twofold. One is to look at the systems and structures and undertake that institutional change. And then the second thing is also create the environment that will allow for diversity to flourish.
I'll add on to Angela's points. I would say in my setting, in the law firm world, the pathway to partnership has historically been a black box, right? What does it mean to make partner? How do I get there? What do you do? And when you talk to more partners, you start seeing that every circumstance is different. There isn't this clear pathway on how you can make partner within a law firm. And so it's actually something that Snell and Wilmer did this year is we had task forces put together to look at the last 5 years of partnership classes to see, the quantitative and qualitative factors of what it took to make partner, and publish this memo to our attorneys in an effort to create transparency, to make it not a black box kind of, well, what do I do? How do I get there? And be able to, enable associates who want to go on the partnership track to, make the calculation and decision for themselves on where they want to go. And I think other sort of avenues that law firms are starting to do our sponsorship programs, right? There's a difference between mentoring and sponsoring. You can think of sponsorship as mentoring on steroids, and what enables sponsorship programs to succeed for women and minorities is that it gives them access to connections that they might not have otherwise had if not for the program. I mentioned earlier about insider-outsider dynamics. Now, I am not going to feel as easily comfortable going to someone who is, let's say, someone who looks different than me to ask, questions that I think are, not, smart or, dumb questions that I would feel uncomfortable asking to a senior partner at the firm who is on the management committee, for example. And so these sponsorship connections really create safe places for the proteges to really, get what they need. And get the connection that they need to succeed within their environment, but also leverage the sponsor's social capital within the law firm environment to help enable them to succeed. So it's a twofold relationship. And I'm seeing a lot more sponsorship programs occur in the law firm world, which is great.
I'll very quickly sort of tie some of these wonderful thoughts up. And just for some background, I've had a lot of opportunity to think about institutions thinking about this. I just came off of a stint as the interim chief diversity officer for the larger University of Denver. And one of the things that I learned in that role is really the kind of massive investment in structural resources that firms, certainly any other institution, needs to make, right? In terms of mentorship programs, pipeline programs, right? reimagining its policies and practices, right, to change the culture. And so what I would tell everybody here, right, I think it's, we need to be more forthright in really sort of asking what those resources look like. The way I've learned it is, look at a budget, right? You can really see an organization's values by how much money they're choosing to invest in that type of work. And so that's a hard thing to do, right? And so I think also to connect to the question of color blindness, right? I think one of the challenges that we have, particularly in the space of the Rocky Mountain West, right, is this idea that this larger narrative, this larger history, right, is disconnected, right, to the institutions in which we're working in. And I think that's the other piece is having forums like this. I certainly think law schools have a huge role to play in challenging that narrative, and of course, giving the history, but also giving the tools to then start, certainly helping all of you as students, helping all of us as faculty, our colleagues that are in the profession, right, to start making that change.
Well, thank you all for that really wonderful discussion on these questions. We have some follow-ups that are more applied to how students and attorneys can make an impact and be more DEI conscious in these spaces. So one question that I would like to pose to you all is, how can students and attorneys begin incorporating some of these regional and contemporary inequalities, historical and both what we see present day, into our advocacy work? And also, what can we do beyond that to begin healing some of this historical inequity and damage that has been done before us and to this present day?
I will take this question.
Go ahead, Joann.
I'll take this question from a perspective of implicit bias. So for me, like I mentioned, when you look at it from a behavioral level, it just comes down to how we make decisions and how we, think. And I think the key to really, it starts with the self, right? I think the key to any implicit bias work is really acknowledging we all have biases that are shaped by our experiences and our identities. And as a human, we constantly make decisions based on these unconscious biases and develop schemas, right? And a schema is a system in which we organize and perceive things that we encounter. And in light of our unconscious biases being more automatic thinking, it's really important as an individual to be intentional and aware and slow down your brain versus using, fast brain thinking. And so two things from an individual perspective. I encourage everyone to do some personal exploration, reflect on your own biases and understand the neuroscience behind it. I think it's also important to recognize the different types of biases that exist and embracing mindfulness as a tool to practice slowing down your brain to make sure that you're making intentional decisions to behave more consciously. And I think from a, organizational perspective, I think organization behaviors tend to usually be stuck in this is the way we've always done things mentality. And so you have to be intentional and communicate the benefits of implicit bias training and provide to others so that they can be aware of their own individual biases. Now, it's also important to note that implicit bias training does not alone completely shift people's awareness. This goes back to the points Angela and Tom made earlier, that the organization's systems and structures can help reduce bias as well, such as, examining job postings, how are resumes screened? How do you conduct interviews? How do you assign work? Mentoring and sponsoring, who you choose to mentor and sponsor, performance reviews. All these things is where an organization's, systems and processes where unconscious bias can creep in. And so I think the bottom line here is that people make up the culture of any organization. And the best thing that we can do, low-hanging fruit here, is to acknowledge the part that we individually play in our everyday interactions with each other, the culture, and the way that we navigate and experience the world.
That is absolutely wonderful. I don't have much to add to that because I think you covered it quite well, Joann. The one thing that I will add to the individual experience and the kind of everyday inclusion at the behavioral level that individuals could do, I often advise people, and I would advise you all to think about the areas where you have power and privilege. And everyone has some area, right? Whether it's in an organization that you're a part of, whether it's a club you're in, whether it's in a non-professional context, right? Think about areas where you have some influence or say. And think about how and who is not being included. And is that intentional? It's a really easy question to ask yourself. And if you get in the habit of asking yourself, is whose voice is not here? Whose voice is not here? And if you're committed to diversity, equity, inclusion, and you're really thinking about it in that way, you're going to start thinking about various identities and ask yourself this, when you're making decisions, have I heard from, have I considered this other point of view? Who can I bring in? And or when you have power, privilege, and you have the opportunity to make decisions, is there a way that you can share that or amplify the voice of another? I think those things, and it's actually one thing, it's just a variety of ways of looking at it, is a really easy way to begin to make small shifts within the realm and sphere of your control. To begin to make change. And as you grow in your career, as you grow in, the stages of your profession, and as you get to various levels, you'll be able to make that a habit and it will become part of how you operate. That's kind of what we talk about when we say things like integrating DEI and embedding it into practices. It's both into policies, but also into individual people practices, your practices, right? If you want to take that diversity lens and apply it to your decisions, do that, make it a habit. And then when you have more power and authority to build systems, when you're looking at things like, how do we admit people to this association, you can begin to make some of those changes that open up doors, promote more inclusion versus excluding people.
And I'll add, I think there's things, particularly for the students in here, right, where you can imagine, start building up those practices, those habits right now. Look at your syllabus for each of your professors, right? Look at the readings, ask those sorts of questions that Angela's talking about. Because they're legitimate and they're questions I can certainly say that myself as a faculty member welcome, because I think the other piece I think that I certainly haven't said is that there needs to be a humility to this work. I certainly don't know everything. And I can tell you in terms of this work, the landscape changes all the time, and that's fine. And I think we all need to take accountability and, push each other in being able to move, forward together in terms of how we deal with these questions, the communities we build, and certainly how we respond to them.
Thank you again for those wonderfully thoughtful responses. I believe we only have time for one more question. I know we've covered a wide variety of DEI related issues, both historically and contemporary. We've discussed at length, especially those that are visible, identities that have been disadvantaged or somehow made less of a priority in our legal education and system, broadly speaking. Can we touch lightly upon those identities that are less visible, those such as neurodiversity and sexual orientation and identity, such as those that might also be implicated in this legal history of exclusion?
I can begin. So this one is, I think a really important one, right? Because we often talk about the obvious aspects of diversity, and there are non-obvious and sometimes called invisible aspects of diversity, like you just mentioned there, Meg. Neurodiversity, non-visible disabilities, and chronic medical conditions that are disabilities, mental health conditions, as well as sexual orientation, gender identity. There's a lot of things that are unseen, and usually this is talked about in the iceberg. iceberg model of identity. It's social identity, right? There's these things that are above the waterline. If you think about an iceberg, there's this tip that's poking out above the waterline. Those are the things that you can see. And then underneath the waterline are these identities about people that you may not see. And then there's also some that are at the waterline that can either, float up above or below, depending on the context and the circumstances. And what I often think about is that there is always diversity in the room. Whether you see it or not, it is there. And part of the reason why there are non-obvious disabilities or diversity and non-obvious conditions and identities that aren't brought into light is because there still is stigma. I'm just going to put it right out there. There's still a lot of stigma and lack of understanding. And I think having more awareness, having conversations like this, and really pointing out some of the statistics. So for instance, if we want to look at something like sexual orientation or disability, the US population, about 5% of adults identify as being out or a member of the LGBT community. In the legal profession, it's 2.5%. For disability, 26% of the US population has some sort of disability. The vast majority of those disabilities are non-obvious, unseen disabilities. Meanwhile, if we look at law firms, associates, and partners, 1/3 of 1% identify as having a disability. Now, my theory on this is not that there are not people that have disabilities or who are LGBTQ plus in the legal profession. They're there. The environment is not conducive, and it may not be safe. And I mean safe both in the emotional, physical terms for them to disclose, right? And I think that's where culture comes in, and creating a climate where diversity is valued, every aspect of it, that there is value in those experiences, that there's value in those perspectives, and we need, hear, and want those in the profession. Until we get more of that, I don't think we're gonna get more disclosure, but I do think the conversations need to happen, and that work definitely needs to happen.
Well, thank you so much for that wonderful response, Angela. In the few minutes remaining, do you have any additional thoughts to add, Tom or Joann? Okay. Well, this concludes our first moderated discussion. I am so grateful for our panelists' wonderful, thoughtful responses and presentations on this incredibly important topic. Thank you so much to our audience members and to everyone that has contributed to this symposium. Thank you.